Hi! In this video, we are going to explain the process for obtaining a civil protection order in King County. My name is Mary Laskowski, and I'm the Training and Outreach Coordinator for the Children's Justice Center of King County in the King County Prosecuting Attorney's Office. This video is the fourth in a series of 5 videos about the protection order process. We will explain what to expect at your return hearing. Since this is a general overview, there may be some differences with your unique experience. The date of your return hearing can be located on the top right corner of the temporary protection order. Most people attend the return hearing virtually or by phone, but you are always welcome to appear in person. Please visit the Superior Court Family Law website to locate your name and to join the hearing by Zoom. We offer tips to prepare for Zoom hearings and your return hearing on our website. What happens at the return hearing will depend on whether the protected person and the restrained person attend or not. If the restrained person does not appear at the return hearing after being served on time, the court would likely be inclined to proceed without them and may be able to grant the protection order based on what was written in the petition statement. However, if the protected person does not appear at the return hearing, the court will not be able to hear their request and will dismiss the case. If your case is dismissed, any temporary protection orders will expire. What happens at the return hearing also depends on whether everyone is ready to proceed, the restrained person was served on time, and the completed proof of service document was filed with the court. Sometimes the restrained person gets served, but proof doesn't get filed with the court. In other cases, service doesn't happen before the return hearing at all. Even if service was complete, someone may not be ready to proceed. These are all reasons the court may be inclined to grant a continuance, set a new return hearing, and reissue the temporary protection order to that new date. In the case of a continuance, the return hearing may feel like more of a check-in hearing with the court, where the judge addresses what must be done before a full hearing can take place. Keep in mind, it is normal for a case to be continued several times. If all requirements are met, the return hearing will become the full hearing. The hearing will start with the court calling the case by its number and title, which is the last names of the petitioner and the restrained person. The judge has a lot of different responsibilities during the hearing, and there may be times when they must establish certain things out loud for the court record. At the beginning, this could be stating the date the order was filed and served, and confirming proof of service is in the court file. It could also be swearing in both parties and having them state their name. For a contested hearing, where the restrained person does not agree to the entry of a protection order against them, the judge will give instructions as the hearing goes on and explain when it is each side's turn to speak. The person requesting a protection order will typically start, present their case to the court, and highlight why they need a protection order and anything relevant from their written statement or submitted evidence, such as police reports, photographs, or text messages. When you speak, it is important to reference the harm or threat or fear of harm that brought you to court and any history of harm there may be with the person you are requesting protection from. If there is something you want to say but aren't sure if it is helpful to the judge in making a decision, just ask. After you finish, the restrained person gets to address the allegations against them. When they are finished, you get another chance to respond. It may be helpful to take notes while the other person is testifying so that you can reference those notes to address anything they mentioned that you might disagree with, need to clarify, or did not speak about earlier. If the judge has any questions, they will ask their questions. The judge will then give their ruling as to whether they are granting or denying the protection order. If either party has an attorney, the full hearing will look similar, except the attorney would address the court on their client's behalf. If you disagree with the judge's decision, a reconsideration or a revision can only be considered if you file it within 10 days of that decision. If the restrained person appears at the hearing and agrees to the entry of a protection order against them, it's considered an uncontested hearing, and the court may not need to hear your arguments in order to grant the protection order. After the full hearing, the paperwork must still be received by or served to the restrained person because a full protection order cannot be enforced if there is no proof of service in the court file. If your protection order is granted, you will want to write down the expiration date somewhere you can't forget so that you can file a renewal order about 1 month before it expires if needed. The next video will cover how to renew, modify, or terminate your protection order. Please visit our website for additional information and resources or to learn more about this process.